Hello, my name is David Behrens. This is a case brief for MMC4200. Section A. Case name and identification of the parties. Press Enterprise Co. is the plaintiff versus Superior Court, which is the defendant. Full case name. Press Enterprise Co. versus Superior Court of California. Number 82-556. Section B. Cause of action. Press Enterprise Company joined a state petition in the Superior Court of California for the County of Riverside to release the transcript of a closed preliminary hearing in a murder case. Section C. Facts. Robert Diaz was a nurse accused of murdering 12 patients by giving them massive overdoses of heart medication. Diaz moved to exclude the public from his preliminary hearing, which permitted closed hearings if necessary to protect the defendant's rights to a fair trial. The judge granted the unopposed motion due to the national publicity the case had received. Section D. Proceedings. The preliminary hearing began on July 6, 1982, and lasted 41 days. All charges were held for court. At the conclusion of the hearing, press requested release of the transcript, which the judge denied. The Superior Court also denied the request, ruling that the release of the transcript might prejudice Diaz's right to a fair and impartial trial. Press appealed to the Supreme Court of California, which denied the request, holding that there is no First Amendment right of access to preliminary hearings. The United States Supreme Court granted, I can't even try to pronounce this word, certiorari. I tried. Section E. Issue. The issue in this case is considering the appropriate standard to be applied by a judge in determining whether the public's right of access to the preliminary hearing should be limited due to the risk of damaging a defendant's right to a fair trial. Does the public's constitutional right to access criminal proceedings extend to pretrial proceedings? Does the standard for closed preliminary hearings under the California Penal Code violate the constitutional rights of the public? Section F. Holding. The California Supreme Court had decided that the preliminary right of the defendant is the right to a fair trial and that the public's right of access must give way when there is conflict. The United States Supreme Court did not agree. In this case, because the defendant had requested a closed preliminary hearing, the right asserted. Section G. Reasoning. Chief Justice Warren E. Burger, writing for a 7-2 majority, reversed the California court. The Supreme Court held that the First Amendment right of the public access applies to preliminary hearings. Closed preliminary hearings are only permissible when specific findings on the record show that the closure is essential. The California court should have asked whether there was a substantial probability that the accused's right to a fair trial would be prejudiced, and whether any reasonable alternatives to closure could protect that right. Justice John Paul Stevens dissented, arguing that the right to fair trial in this case was more significant than Press Enterprise's interest in getting the transcript. H. Rule of law. The California Supreme Court decided to close the preliminary hearing upon finding a reasonable likelihood of substantial prejudice, which would infringe upon the right to a fair trial. Penal Code Section 868 makes clear that the primary right is the right to a fair trial, and that the public's right of access must give way when there is conflict. So, I have a hard time with a lot of the legal verbiage, and after reading through both sides of the case, I mean, I understand why this is an important decision, important ruling, because it is our right to have a fair trial. I get that. It's very important. And I understand, because probably if I had to go on a jury for a murder trial and I already had a preconceived notion of what was happening, going on, it's going to sway my decision. So I understand what they had to do, but it's also, important that the pool from which the court systems are able to pick jurors and do all this, that they are informed as well. So it's kind of this double-edged sword. Like, should they release that information? Should they not? Um, so I thought it was an interesting case. Like I said, I have a hard time with the verbiage, but after reading through it a bunch of different times, I kind of can get the gist of what was happening. So hopefully you enjoyed this little slide presentation. Thank you.